More than a decade ago, in the wake of the exonerations of several innocent black men from North Carolina's death row, a few people in the Capitol defense community had an idea. We wanted to force North Carolina to reckon with the death penalty's legacy of racism. Many people said it couldn't be done, or that it would make those in power too angry and shouldn't be done. But we pushed forward anyway. We worked with Carolina Justice Policy Center, the NAACP, Murder Victims' Families for Reconciliation, and other agitators to build grassroots support. We enlisted partners in the legislature, especially members of the Legislative Black Caucus, and helped craft the Racial Justice Act, a first-of-its-kind law that would allow people on death row to bring forward evidence that racism contributed to their death sentences. The state would not be allowed to execute anyone who proved that race was a significant factor in their sentence. This law prompted the first-ever statewide investigation of racism's role in capital trials. A study by researchers at Michigan State University found that, across North Carolina, crimes against white people were twice as likely to be punished with the death penalty. It also found that black citizens were systematically denied the right to sit on capital juries, silencing their voices in a system that disproportionately sentences black people to execution. We used this evidence of clear and compelling statistical patterns, along with a trove of evidence from individual cases, to file claims on behalf of our death row clients. And in 2012, the first 4 won their claims and were resentenced to life imprisonment. But that was only the beginning of the fight. As Brian Stevenson testified at the first RJA hearing, the history of racial justice is one of overcoming resistance. When there is an advance, inevitably there is pushback. Some were angry that we dared call out racism in our courts. In 2013, a legislature hostile to seeing African Americans operate the levers of power, whether it be in voting or in serving on a jury, repealed the RJA and tried to invalidate all remaining claims filed under the law. A few years later, the North Carolina Supreme Court also overturned the cases of the 4 clients who'd already won. One of these clients had worked his way to medium custody. Another had gotten her GED and reconnected with her children. All 4 of them had to go back to death row. That was an incredibly painful time of loss. Many thought the RJA had been a failure. But we refused to give up. We simply couldn't allow the kind of evidence we'd uncovered, clear proof that racism infects the courtrooms where life and death decisions are made, to be ignored and thrown away. So we kept fighting for our clients' constitutional right to have their RJA claims heard in court. We had to bring their evidence into the light. In August 2019, we argued for this right in front of the North Carolina Supreme Court, and in June 2020, the court responded with a courageous decision. It issued a ruling granting every person on death row with a pending RJA claim the right to present their evidence in court. The decision breathed new life into the Racial Justice Act. Claims that illuminate the ties between racism and the death penalty will now be heard in dozens of North Carolina counties. Our state can finally begin the process of reckoning with the racist legacy of a punishment that threatens innocent people and values white lives above all others. Now we enter RJA the next decade. There is so much more work to be done. We have always counted on the support of this community, and we are grateful to continue to work beside you.